Michael, do you have any final thoughts that you want to leave with the audience following today's presentation?
Sure. I think the ultimate thing to think about is just really, as we're in an era now where we have a lot of patent auctions, patent sales, transfer of patents between patent owners and then non-practicing entities, patent aggregation companies. It's important to think about how these judicial estoppel and assignor estoppel and patent owner estoppel issues are going to impact you. And so if you are going to be purchasing patents from somebody or you're selling your patent to somebody, think about the fact that if you're going to district court litigation, if you're the former patent owner, you may not be able to challenge the validity of those patents, but at the patent office you can. And so just be aware that when you're engaging in any of these commercialization or monetization of your patent portfolios, just understand that statements that you have made in the past will be relevant to any challenge that you may be involved in with respect to those patents. And you may or may not be foreclosed from being able to challenge those patents, whether it be in a district court or PTAB proceeding. So just be aware that when you're involved in those proceedings, that prior activity may be relevant still. And so, one thing to think about is, instead of licensing intellectual property, instead of selling intellectual property, maybe you license it, because that way it remains under your control and in your possession. And so you can't have somebody asserting those rights against you. It's a way of monetizing without walking yourself into a risk of those patents may be asserted against you. But just, think about the fact that everything that you do in the patent office or in court may come up again later on in PTAB proceedings.